In our view, going by the outlined principles, it is obvious that this court lacks a jurisdiction to re-examine this matter with a view to incorporating the proposed additional orders. First, the nature of the orders sought are neither arithmetical or clerical. Secondly, the applicants seek to enlarge the extent of the orders to accommodate fresh factual circumstances that emerged after the judgment was delivered. Further, even assuming that a re-evaluation is possible through a review, it will be subject to stringent legal conditions which must be met, one of which is that no appeal should have been filed. Already, there are multiple appeals that have been preferred, namely Civil Appeal number E096 of 2025, E098 of 2025, E103 of 2025, E105 of 2025, and I believe that's it, which would make an application for review untenable. Moreover, listening carefully to the applicants, it is apparent that they are dissatisfied with the extent of the orders granted by this court. They thus propose amendments to bar the fourth respondent from continuing to discharge his duties as the Speaker of the National Assembly, and declaration that the proceedings that have been presided by the fourth respondent subsequent to the judgment of 7th February are unlawful, illegal, and void, and an order that the fourth respondent should personally bear the cost of the application. In our view, if the applicant is unhappy with the scope of the orders, the remedy lies in lodging an appeal. I will go to the next issue, which is whether the third respondent ruling of the 12th of February 2025 was issued in deliberate and willful disobedience of clear terms and directions set out in this Honorable Court's judgment of the 7th of February 2025, thereby constituting contempt of court. It is strict law that contempt of court connotes any act that defies or is disrespectful to the court and may be manifested in different ways. This includes deliberate refusal to obey a court order, showing respect towards the court during judicial proceedings, that is contempt in the face of the court, or scandalizing the court with misinformation. The law governing contempt proceedings in Kenya was explained in the case of Alfred Mutua vs. Boniface Mwangi, 2022, as follows. This is quite long, and well, I should read it. I think I will skip that. I'll go to the next one. The court in Republic vs. Kenya School of Law and two others, ex parte Julius Wanjiro Joroge and 5 others, underscored the significance of contempt of court proceedings as a tool for the observance of the rule of law as follows, and I quote, "In my considered view, court orders are not made in vain and are meant to be complied with. If for any reason a party has difficulty in complying with the court orders, the honorable thing to do is to come back to court and explain the difficulties faced by the need to comply with the order. Once a court order is made in a suit, the same is valid unless set aside on review or on appeal. In Econet Wireless, Kenya Limited was Minister for Information and Communication of Kenya and another, Ibrahim J. as he then was stated, and I quote, "It is essential for the maintenance of the rule of law and order that the authority and the dignity of our courts are upheld at all times. The court will not condone deliberate disobedience of its orders and will not shy away from responsibility to deal with firmly with proved contemners. It is the plain and unqualified obligation of every person against or in respect of whom an order is made by a court of competent jurisdiction to obey it unless and until that order is discharged. The uncompromising nature of this obligation is shown by the fact that it extends even to cases where the person affected by the order believes it to be irregular or void." End of quote. Nevertheless, a party that moves the court in an application for contempt must satisfy the requisite threshold as laid down in Samuel M.N. Mweru and others was National Land Commission and 2 others, where the court held as follows. Quote, open quote, "It is an established principle of law that in order to succeed in civil contempt proceedings, the applicant must prove 1. the terms of the order, 2. knowledge of these terms by the respondent, 3. failure by the respondent to comply with the terms of the order. Upon proof of requirements, the presence of willfulness and bad faith on the part of the respondent would normally be inferred, but the respondent could rebut this inference by contrary proof on a balance of probabilities. Perhaps the most comprehensive of the elements of the civil contempt was stated by the learned authors of the book Contempt in Modern New Zealand, who succinctly stated, and I quote, "There are essentially 4 elements that must be proved to make the case for civil contempt. The applicant must prove to the required standard in civil contempt cases, which is higher than civil cases, that 1. The terms of the order or injunction or undertaking were clear and unambiguous and were binding on the defendant. 2. The defendant had knowledge of or proper notice of the terms of the order. 3. The defendant has acted in breach of the terms of the order. And 4. The defendant's conduct was deliberate." The specific directions were contained in the order that was read out in open court in presence of the then respondent counsel. The specific directions contained in the order that was read out in open court in presence of that respondent counsel were as follows, and I quote. Number 1, it is hereby declared that the question as to which party or coalition of parties is a majority in the National Assembly in the 13th Parliament was determined by the sovereign will of the Kenyan voters during the 9th August 2022 general elections. 2, it is hereby declared that the Honorable Speaker's ruling or determination contained in his communication from the chairman on the 6th of October 2022 on the majority and minority in the National Assembly violated Article 108 of the Constitution and therefore is null and void. 3, it is hereby declared that the Honorable Speaker's ruling or determination from the chair on the 6th of October 2022 with respect to the leadership of the National Assembly on account of its determination of the majority and minority party in the National Assembly is contrary to and violated Article 108 of the Constitution and to that extent is null and void. 4, an order of statutory is hereby issued quashing the Honorable Speaker's ruling of determination contained in his communication from the chair made on the 6th of October 2022 on the majority and minority party in the National Assembly. And then 5, subject to the foregoing orders, the rest of the prayers in the petition are declined. And then lastly, parties will bear their respective cost. These orders are explicit. They are mainly in the form of declarations and an order of statutory that quash the specific decision made by the Speaker, then respondent, on the 6th of October 2022. Declarations, in their nature, do not require a party to take any specific action or refrain from doing anything. They simply declare the legal position as it is. If that position is contravened, the party offended can then, based on the declaration, seek a remedy founded on the declaration. This position is buttressed by the decision of the Court of Appeal in Attorney General versus Barra, where the court held as follows. In any event, had the appellant properly understood the final decree, he would have appreciated that the learned judge simply issued declarations clarifying the law. And declaratory order means a ruling that is explanatory in purpose. It is designed to clarify what before was uncertain or doubtful. A declaratory order constitutes a declaration of rights between parties to a dispute and is binding as to both present and future rights. Declaratory judgments are typically sought as means of preventing a dispute by removing legal uncertainty as to the applicable law and the rights and obligations of the parties. H.W.R. Wade in Administrative Law, 5th edition, at page 523, stated as follows in reference to a declaratory judgment. Quote, a declaratory judgment by itself merely states some existing legal situation. It requires no one to do anything, and to discard it will not be contempt of court. By enabling a party to discover what his legal position is, it opens the way to the use of the remedies to give effect to it, if that should be necessary. It is clear from the above definition that a declaratory judgment is limited in its powers. All it can do is clarify a legal relationship or state of affairs by stating the court's opinion of it. In other words, it states the court's authoritative opinion regarding the exact nature of the legal matter without requiring parties to do anything. We therefore find no proof of deliberate and willful disobedience by the land exponent of the specific terms of the orders we issued on the 7th of February 2025. Hence, it is our finding that the contempt of court has not been established. The application lacks merit. Each party shall bear its own costs.
Okay. And with that, we shall adjourn.